Hey everybody, today we're going to talk about a recent Supreme Court ruling that could have a huge effect on the copyrights of your music. I'm your host Mark LV, this is Band Advice TV. Hey everybody, welcome. So a couple months ago, the Supreme Court made a ruling on the case of Fourth Estate Public Benefit Corporation versus wall-street.com. Now, this ruling is going to have some impact on the copyright law as we know it. But before I go into the details on how that's going to affect you, let me give you a little bit of background on the laws that we're talking about. So, back in 1976, the Copyright Act of 1976 went into effect. Now, one of the things that Copyright Act stated is that an intellectual property, once it's affixed to a permanent medium, has copyright protection. So what's that mean? Okay, so once you write the lyrics down to your song, or once you record it on your iPhone, or you film yourself performing it on YouTube or Facebook, it's affixed to a permanent medium. Those are all permanent sources. So therefore, you have copyright protection. However, there is a stipulation to that. If you wish to file an infringement suit against somebody that's violating your copyright, it has to be registered first with the Copyright Office. So ever since I was a kid, I was under the impression that the moment the Copyright Office receives your registration package, which that includes your form, your check for whatever the fees were, and your 2 copies, be it 2 cassette tapes, 2 CDs, 2 pieces of sheet music of the song that you're copywriting, once they had that in their hands, you were protected. So one of the tricks that we would do is we'd send it certified mail so that when we get the certification back, we know they have it. Or we wait till the check clears and we'd know we'd have it. And then we're good to go. We're registered, totally protected. Well, apparently that's not the case, and it's not really clearly defined as to at what point in time your copyright is registered. So that's what brings us to this lawsuit. So in this case, Fourth Estate Public Benefit Corporation, their content provider, wall-street.com, they're a website that licensed contents from Fourth Estate. Well, the license expired. Wall-street.com did not remove their content from the website, so Fourth Estate says we're going to sue you for copyright infringement. And they turned around and they sent off their registrations and then almost immediately filed a lawsuit against Wall-Street. Wall-Street says, can't do it. You're not registered. Why, yes, we are, says Fourth Estate. Oh, no, you're not, says wall-street.com. You don't have your certifications yet. And that's what lands us here in the Supreme Court. So there's 2 schools of thought, application approach and the certification approach. Application approach is what I always believe to be the case, where once the application is in the hands of the Library of Congress, you're registered, you're good to go. Certification approach says you are not registered and good to go until you receive your certificate of registration. Here's the problem. Copyright Office is swamped, and there's so many people submitting stuff that it could take 8, 10, 12 months to get your certification back. Well, unfortunately, the Supreme Court sided with wall-street.com, and the certification approach is now law. So what's that mean? You can't litigate against copyright infringement until you receive your certification of registration or your application has been refused. Why refused? Because sometimes clerical errors, other things that are preventing it from being approved happen and it's sent back to you to correct. You can litigate if that happens because, once again, you got 8, 10, 12 months before you may even find out that your registration has been refused. So, first thing that goes through my head, which I'm sure did for a lot of you guys as well, is great. Now I got to wait 8, 10, 12 months to release this really awesome song because, heavens forbid, I do and have no legal recourse other than a cease and desist letter, which really, honestly, isn't worth the paper it's written on. And then that whole time, this person that stole my stuff is making money off the deal. But I do have some good news. Once you do have your certificate of registration, you can go back and litigate against anybody that has violated your copyright from the point in which you first had copyright protection, from the point in which you first affixed your lyrics to a piece of paper, or sang your song into your iPhone, or broadcast it out on YouTube, that moment in which you affixed it to a permanent medium. So there you go. Big changes in copyright laws. I do want you guys to keep this in mind, though. 8, 10, 12 months, that's a long time for your registration to be floating around in a government process. And if by chance somebody wants to rip you off and wants to register that song as their own, and they happen to get it in the fold and get their certification back before you, you're out of luck. You really are. So I urge you to get your registration filed as quickly as you can. You can do it online for $50, or you can go the old route of filling out the forms and sending off your 2 copies and a check for $35 or whatever the price is these days. So there you go. Some pretty significant changes in copyright law. I hope you guys take this to heart. And if you wouldn't mind, go ahead and click subscribe and click the little bell so that you get notifications. And until next time, I'm Mark Allen V, and this is Band Advice TV.